Matter of DT versus the Archdiocese of Philadelphia. Can we please have appearances of counsel?
Morning, Your Honor. Chip Becker here for the plaintiff DT. Good morning, Justices. Nicholas and Trello on behalf of the Archdiocese.
Good morning, Your Honors. Alex Daniel.
Morning, counsel, and welcome. Mr. Becker, please go ahead.
Mr. Chief Justice, and may it please the court, my name is Chip Becker. I'm here for the plaintiff DT. As a first order of business, may I reserve 5 minutes for rebuttal?
Have you back, perhaps a little less, but we'll have you back. Please go ahead.
I'm here at your discretion, Your Honor. Thank you. This appeal arises from a tragic and difficult story involving the sexual abuse of a teenager in Margate, New Jersey, at the hands of a Roman Catholic priest employed by the Archdiocese of Philadelphia. As I'm sure you know, this case is one of several percolating their way through the New Jersey courts involving the clerical abuse of minors at New Jersey Shore homes. This case is the first to reach this court. The question presented is whether the Archdiocese of Philadelphia has subjected itself to New Jersey's specific personal jurisdiction by virtue of its employer-employee relationship with Michael McCarthy, the priest, who formed a relationship with DT's family and with DT, and who ultimately abused DT at his New Jersey Oceanside home. The answer to this question is yes. Michael McCarthy was an employee of the Archdiocese of Philadelphia. His job description included developing pastoral relationships with parishioner families. It included developing a mentoring and spiritual guidance relationship with the children of parishioner families. It included providing support to families grieving the loss of a loved one. Indeed, DT's family was grieving the loss of DT's father when Father McCarthy came on the scene and took DT under his wing. When he did this, it was not as a friend. It was not as a neighbor. It was in his professional capacity within the scope of his employment for the Archdiocese. What flowed was a continuum of conduct that started in Pennsylvania and continued in New Jersey and back again, that was predicated on a job description and an employment relationship. The undeniable agency relationship between McCarthy and the Archdiocese has direct implications for personal jurisdiction. Under due process principles, an entity is subject to the specific jurisdiction of a state when the plaintiff's claims arise from or relate to the defendant's activities in the state. Here, the Archdiocese acted through its agent, Michael McCarthy. It did so when McCarthy picked up DT at his house, drove him across the Ben Franklin Bridge, traveled on New Jersey roads, stopped at New Jersey traffic signals, parked on a New Jersey street, and entered a New Jersey home, all enabled by and within the context of a professional relationship. On this basis, the Archdiocese is subject to New Jersey's specific jurisdiction in this case. Having just articulated this proposition to you, let me also acknowledge the scope of this argument. First, this is not a general jurisdiction argument. We come before you on principles of case-specific jurisdiction only. Second, as you know, this case involves a record concerning the Archdiocese's ownership of property in various shore communities. I do not suggest that those properties represent an independent basis for the exercise of personal jurisdiction. We proceed on the basis of the Archdiocese's employer-employee relationship with Michael McCarthy and McCarthy's acts within the context of that relationship. Third, I recognize that this record does not contain evidence that the Archdiocese specifically directed McCarthy to take DT to New Jersey. Our argument is predicated on McCarthy's overall course of conduct while performing his job, not a direct order from the Archdiocese. Fourth, let me recognize the sensitivity of a jurisdictional finding that would effectively determine the ultimate question of vicarious liability. I do not mean to suggest here that the exercise of jurisdiction amounts to an advance ruling on the merits. Jurisdiction turns on the Archdiocese's overall activities in the forum that gives rise to this claim through its agent, Michael McCarthy. Liability would focus on the act of abuse alone. Let me suggest that due process principles are flexible enough to permit jurisdiction without pre-deciding liability, giving the spectrum of New Jersey-related activities that inform jurisdiction. Simply put, let's do one thing at a time. Finally, let me acknowledge that I do not come before you with the strongest of hands. There are better records on the issue of jurisdiction. I get that. But this hand is still strong enough to support personal jurisdiction because the Archdiocese is accountable for the entire course of conduct by its agent, Michael McCarthy, and because DT's claim arises from or relates to that overall course of conduct. Even if we are close to the line, we are still within it, and that is enough. with respect for the appellate division, the trial court, my friend, Mr. Centrella, my new friend, Mr. Daniel. Given the principal-agent relationship at the heart of this case, these facts do fit within the uttermost limits of due process. And on that basis, we ask you to reverse the decision of the appellate division, reinstate plaintiff's claims against the Archdiocese, and remand this case for further proceedings.
I want to confirm one point that you made, I think,
Yes, sir.
in your opening. When you were describing driving on New Jersey streets to a New Jersey home, you were referring to the Margate home. You
Yes.
are not relying on the prior ownership of the Ventnor property to establish personal jurisdiction here?
Yes, Your Honor. And I thought I had addressed that point, but absolutely, this is about Michael McCarthy, not the sort of, the Archdiocese was doing stuff in, had homes in New Jersey or had places in New Jersey. This argument proceeds through the relationship of the Archdiocese with Michael McCarthy. And if that is not enough, I lose. But I think it is enough and I should win.
And the claim doesn't in any way relate to or arise out of the ownership of the Ventnor properties?
Correct.
Or the prior ownership of the other property, the other property in addition to the two Ventnor properties?
That's right.
We should just disregard that.
Yes, Justice Patterson, the ownership of those properties has been a theme in the litigation, and by litigation, I don't mean DT versus Archdiocese, but this body of cases has included discussion and awareness of that. And as you are aware, the appellate division twice remanded this case for further proceedings, once with specific instructions on those properties. But that's not really what I'm trying to work with you here.
Let me ask you one follow-up, because you talked about there's no evidence that the Archdiocese directed the trip to New Jersey. Is there any evidence, and you've now had jurisdictional discovery, that the Archdiocese was aware of this trip to New Jersey?
There is evidence to that effect. In fact,
what is that?
There is deposition testimony, and of Mr. McCarthy, Father McCarthy. And if you allow me to turn to the appropriate page in my brief, on pages 768 and 769 of the record. Also, and this is a little bit more peripheral, page 801 of the record and page 859 of the record. And by record, I mean the plaintiff's appendix. Forgive me for the nomenclature. There is testimony to the effect that Father McCarthy had previously taken, previous to DT, had taken children to
testimony from whom? Testimony from Father McCarthy
from Father
himself?
McCarthy. Yes.
Any testimony from anyone from the Archdiocese of Philadelphia?
There is
that with regard to their knowledge that he was taking parishioners to this home in New Jersey?
There is. I'm going to answer your question indirectly. There is testimony from DT about what he thought. Your Honor, I do not. We don't cite that. Let me answer it this way. We don't cite that testimony in our briefing. I think the testimony from Monsignor Koutis is more in the nature of describing the work of a priest and the relationship of the priest to the Archdiocese. As I stand here, am not aware of testimony by the Archdiocese that they knew that Father McCarthy was taking children to the shore, or that they directed DT to take him to.
Well, sure, and you indicated lack of direction, but as to this particular child and this particular trip, is there any evidence that the Archdiocese was aware in advance of the trip? Obviously, they're aware now, but
no, Your Honor. No, there is that testimony. We don't have that testimony that there was some kind of direction.
No, I'm not asking about direction.
No,
you've already covered direction. I just want to know, was there any evidence of that they knew this was about to happen, or knew about it at all until after the fact?
So I would point you again to the testimony that I identified at pages 768 and 769.
And just to be a little bit more specific about that, McCarthy did testify that other priests knew he brought teenagers to his Margate house, that the pastor at St. Bernadette's, where he worked, knew where McCarthy was going, and this is a direct quote, almost any time he was in or out.
Yes.
And that other teachers and administrators at Cardinal O'Hara, the school, knew as well.
That is exactly the testimony.
And he testified that no one from the Archdiocese ever told him that he could not take children from his parish to the shore, even though they knew that he was doing that.
Justice Apter, that is exactly the testimony. And so I want to be careful, Justice Patterson, and acknowledge that I don't think, powerful as that testimony is and important as it is in terms of framing the discussion around DT, I can't come to this court and say that there is testimony along the following lines. Father McCarthy called the Cardinal and said, hey, I'm taking DT down to the shore. And the Cardinal said, absolutely, have a great time. Right. The testimony doesn't organize in quite that way. The testimony, as Justice Apter described, is that absolutely the school knew, the parish knew, this was common knowledge. Father McCarthy didn't go anywhere without people knowing, and more than that, that Father McCarthy essentially used this shore home, his shore home, as almost an external office where he would bring children, he would bring families. This was part of his one of his pastoral offices, as it were, in doing his work at St. Bernadette's Parish. So I think there is actually significant testimony on the record, but Justice Patterson, perhaps not quite within the formulation that I think I was hearing from you.
Yeah, no, but I'm the Archdiocese itself. Is there any evidence that they had knowledge about this trip?
Well, if we're going to
I'm not
distinguish,
talking about just the Cardinal, because obviously it's an organization.
Right, I understand.
People in it.
So if we're going to distinguish the Archdiocese, excuse me, if we're going to understand the parish and the school as distinct from the Archdiocese, then to the point that Justice Apter was making, there is certainly testimony that the school and the parish knew.
And other priests.
Right. But there is, Justice Patterson, not testimony that, quote unquote, the Archdiocese knew. Of course, all of this is under the umbrella of the Archdiocese. But the testimony doesn't come in quite in the formulation, Justice Patterson, that you described.
Thank you.
You said your case is based on agency principles. What is your strongest case support or statutory support or any kind of support for the idea that an agent can subject their employer to specific personal jurisdiction by committing a tort in a particular state?
So I would point to one case in particular, in the category of being specific and broad, which is the International Shoe case itself, the 1945 case that grounds our entire body of post-World War II personal jurisdiction. Now, International Shoe is a case about a shoe salesman, right? Working in the state of Washington, and that case doesn't organize because the concepts of specific and general jurisdiction didn't really emerge until somewhat later. But that case is a case about an agent, right? The Bristol-Myers Squibb case of the United States Supreme Court is about agents of the Bristol-Myers Squibb company operating in the state of California and whether that's good enough or not. The Ford case that the U.S. Supreme Court decided recently in 2019 is about the conduct of Ford's agents in the states of Montana or Minnesota. And which is just to say that the idea that corporations act through their agents is entirely unremarkable. And in a sense, the whole sweep of our specific jurisdiction jurisprudence.
So the Supreme Court in Daimler said may be relevant. Is it sufficient in and of itself? Has the court said that?
Well, Daimler, of course, was a general jurisdiction case, not a specific jurisdiction case. So the texture for that statement would be different. I think whether an agent, I would submit to you that whether an agent's conduct in a forum is enough to trigger the specific jurisdiction depends on the nature of the conduct. What is the agent doing? And does the claim, to use the formulation that really is concisely summarized in the Bristol-Myers Squibb case and also the Ford case, and that we now have, I think, is the neat formulation for specific jurisdiction. The question is whether the plaintiff's claim arises from or relates to the defendant's conduct in the forum, whether there is an affiliation between a claim and those and that conduct. And that conduct is when it comes to corporate entities, and the Archdiocese is not, as I understand it, strictly speaking, a corporation, but But these are all cases that involve corporations or some kind of entity that is acting through people. What is unusual about this case is that we are focusing on the agency relationship itself. Usually in these cases, the fact that corporations act through their agents is unremarkable and not really noted. And so what we look at is not the fact of the agency relationship, we actually look at what the agents are doing. And then we ask ourselves whether that's enough.
Generally, you would agree that personal jurisdiction and agency are really distinct concepts.
Well, they are distinct concepts as a matter of law, right? Personal jurisdiction is something that we think of now within the framework of due process and really our federalist system. Agency, in contrast, is a common law doctrine that describes the relationship between principals or employers and employees and others, but they intersect with each other and certainly do in this case. Yes.
I'm sorry.
No, please go ahead.
That's what I wanted to hone in on. You said common law. What body of law controls whether the priest is an employee of the Archdiocese? Common law or canon law?
Well, a common law.
Why?
Because this is a legal question for you to answer, and canon law is, I mean, with great respect to the traditions and significance of the Roman Catholic Church, canon law is something like an employee handbook. It's policies and procedures.
Well, before interpreting what canon law is, I'm just concerned with which body of law controls.
Well, I mean, so let me give a more textured answer. I think ultimately for this court, it is the common law that describes, that frames an analysis of whether there is an employee-employee relationship. Or let me put it differently, whether there's a principal-agent relationship between the Archdiocese of Philadelphia and here the priest. But canon law, the internal, the body of principles and customs described as law and enforceable as law in some settings, right? That what we call law provides perspective, I would suggest, on how the archdiocese and how the priests understood that relationship. But ultimately, this is the Supreme Court of New Jersey. This is not a canon law court.
I understand.
Right. So I would think canon law is something more like evidence, but the common law is ultimately the framework for your decision.
Either way, in terms of agency principles, the relevance of that is a liability determination about whether the employer is responsible for the actions of the agent. Here we're talking about jurisdiction. So how does agency even come into play when your main question is whether there's specific jurisdiction?
May I ask you to, because there were a couple of parts to that question, and I just want to make sure I understand them. May I ask you just to repeat the question?
Oh, sure. Agency law essentially addresses liability concerns, whether the employer is responsible in the doctrine of respondeat superior for the actions of the agent. How does that even come into play when we're only concerned with here about whether personal jurisdiction exists?
Okay, so let me push back on your construction of agency law. Agency law is a body of law that describes relationships between entities and people, or entities and entities, people and people, right? The agency law may have a variety of applications depending on the circumstance. It may apply to questions of liability and vicarious liability, right? We understand in lots of settings whether a business is responsible, is vicariously liable, or a hospital is ostensibly liable for the conduct of someone else is a function of those agency relationships. But while we often associate agency law with questions of liability, agency and liability are different constructs. And agency is a body of law that can apply in a variety of settings, including jurisdiction. For example, here. For example,
let me ask you, because when we look through the jurisdictional cases, you cite Hardwick agency case, very closely analogous on the question of vicarious liability, but agency, and you respectfully, I think it appears to be that your route in this case to personal jurisdiction through agency principles is distinct from the analysis on a personal jurisdiction case, which is about purposeful availment not by the individual, but by the defendant itself. And whether the defendant itself took an act in which it purposely availed itself of the privilege of conducting activities within the forum state. I'm quoting from Ford Motor Company there. And a caveat there that the purposeful availment cannot be premised on fortuitous random acts. So we have that construction, and we see that in many, many different contexts, some finding personal jurisdiction, some rejecting personal jurisdiction, but that's the construct. When I see, in your analysis here appears to be entirely premised on a basic step that vicarious liability leads to a finding of personal jurisdiction. And it just seems very far from the U.S. Supreme Court's analysis. And I really don't think that International Shoe is an agency case. It's a personal jurisdiction case.
So I agree with you. It is a personal jurisdiction case. It is a personal jurisdiction case where the exercise of personal jurisdiction is predicated on the acts of an agent in a state.
Yeah,
right?
That is the commerce setting, which is, of course, so important in personal jurisdiction law. When is it that usually a corporate defendant that sold something and the injury is related to what it sold, when is it had purposely availed itself of the good auspices of the state in which is the forum state here? And in many, many commercial settings, the court says you are sending in your International Shoe salesman, or you are sending in your employees to do certain acts and doing business in that state, and that's enough. But we're not dealing with a commercial setting here. We're dealing with something very different. And just following up on one of my colleagues' questions, where's the case that premises personal jurisdiction on a finding of agency that might be very valuable for vicarious liability on the merits of this case, but is a different inquiry than personal jurisdiction?
Well, first of all, okay. So in terms,
question, I apologize.
Right, I understand. So in terms of the case that I would point you to is the Ford case recently of the U.S. Supreme Court.
But in that case, Ford specifically conducted business in the forum state, advertised on billboards, television, radio, print, and direct mail in the forum state, urged citizens in the forum state to buy Ford vehicles, and distributed replacement parts in the forum state. So Ford has nothing to do with premising personal jurisdiction only on the tort of one particular employee. Our question is, beyond a case like Ford, where it seems like it could have almost supported general jurisdiction, that Ford was doing so much business in whatever the forum state was, and they're pointing out all of the different ways that Ford was advertising in the forum state, selling in the forum state, encouraging people to buy products in the forum state. Where is a case that says that one tort of one employee is enough for personal jurisdiction?
Well, I don't have that case for you, Your Honor. And I recognize that Ford is a different case. And that those are, Justice Patterson, Justice Apter, those are cases involving commercial activity. This is a different case. And so my suggestion is that a different analysis is required, not one that is inconsistent with personal jurisdiction, not one that is inconsistent with principles of agency, but just a recognition that this is a different case. And what we are thinking about are these uttermost limits of due process. Is
it fair to say, and you're obviously a tremendously diligent and talented lawyer, is it fair to say that you want us to extend personal jurisdiction where it hasn't gone before? Okay,
so I got an easy one for that. No.
Okay.
100% no.
Where's the case that's done this before?
I don't have a case that's squarely on point with this.
Did you disagree with me when I complimented you, or was I didn't understand?
No. Yeah. I'll tell my mother. Right.
Your mother's saying the answer is yes to that.
No, tell me I'm answering the other part of the question. Right. Okay. No, I am not asking you to expand principles of personal jurisdiction. What I'm asking you to do is to apply those principles, specific jurisdiction only, focusing on the question of whether the plaintiff's cause of action arises from or relates to or has an affiliation with the defendant's actions in the forum. And here, Justice Apter, We don't have, this is not a commercial case. This is a case where the Archdiocese of Philadelphia hired
By
someone
the way,
to be
to
a
compliment you
priest.
that you just confused me with my colleague here.
Oh,
So
well, I was, forgive me, the two of you
quite all
are,
right.
are
I
asking
appreciate-
interlocking
keep doing
questions.
that. Keep doing that.
This is a case where the Archdiocese hires a guy to do a job. Now, they don't tell him what to do. There is a charge letter where they say there's a bunch of very general propositions about ministering to the parishioners. But beyond that, they don't particularly tell the priest what to do.
Okay, let me ask you a very
Father
fundamental
McCarthy,
question. If other courts have done what you say we should do in this case before, what cases have they done that in?
I don't think I have a specific case for you that focuses on agency, the acts of an agent within the context of a non-commercial fact pattern.
And when
right?
you
what I'm asking you to do is to focus on the proposition that the Archdiocese has charged this employee with a job, and the employee has broad latitude in terms of doing his job, and is doing the job, right? Is mentoring and providing spiritual guidance, and within that context does create a relationship with DT's family, and does create a relationship with DT, and brings DT to this home. And yes, there is abuse there, but I'm thinking, and maybe it was, I'm not sure, Justice Patterson or Justice Apter, which of you raised the question of purposeful availment, but the jurisdictional argument, the connection that I am making between agency and personal jurisdiction runs through the relationship, runs through the charge that the Archdiocese gives to the priest, and the priest then performs. And so
is your argument that Father McCarthy's actions were within the scope of his employment because there was no defined scope of employment? So anything he did in New Jersey that somewhat may have involved parishioners was within the scope of his employment. It sounds like you're saying he had no charge, that they really did not give him any direction. So really any and everything that he did falls technically within the scope of his employment. Is that how are you defining?
I didn't mean to suggest that.
How are you defining?
I didn't mean to suggest that wide open.
Okay. Well, what is your argument that this falls within the scope of his employment, given your other argument that that the Archdiocese hired him, did not give much direction, did not define the scope of his duties, and left it up to him generally?
They give him direction. They tell him to minister and to care for the parishioners, and to provide spiritual guidance and so forth, and religious guidance, and to care for the youth of the parish. But if the idea is that I'm going to use the cardinal as my character, that the cardinal is calling up the priest and telling them exactly what to do at any given moment, that's not how this works, right? The priests have, and Father McCarthy in particular, had broad latitude in terms of how they performed their job. And absolutely, it was within the context of that job description that the relationship with the family is formed, the relationship with DT is formed, that that various children and families are taken down to the Jersey Shore, right? And so my focus is not on the act of abuse itself, although, side note, if we were thinking about liability, I would suggest to your honors that your decision in the Hardwood case does suggest that even if we understand the abuse is beyond the scope of his employment, still there could be vicarious liability under the rationale of that case. But my proposition here is not focused on the act of abuse itself.
So
it is focused on the entire continuum of conduct.
Do you disagree with the appellate division's statement? Give me a second. I just want to make sure I correctly quote it. That there was that McCarthy was not acting within the scope of his responsibilities as a priest when this sexual assault occurred in New Jersey.
That's a
pretty critical statement. Is it a yes or a no?
I think it's actually, I mean, if you're really going to push me, of course it's terrible, right? And unthinkable, right? So If I was going to be a little bit more textured about it, I would say that there are settings within which, for example, in the psychologist patient relationship, you can have consensual. There are cases involving consensual sexual relationships, and I'm not trying to push this very far, right?
Yeah,
but
I don't.
No,
think
I understand.
We're also dealing with the child.
I understand. So there's an internal monologue where I want to acknowledge the possibility that a sexual relationship can have a dimension of what I'll call negligence, and there is a negligence claim here. Within the context of a relationship.
But that's different. I mean, there is a determination by the appellate division here, which I think is really crucial to its affirmance of the trial court, that that when we talk about jurisdiction, we're not dealing with vicarious liability, and that he was not acting within the scope of responsibility as a priest when he sexually assaulted plaintiff. Okay, so obviously, this case, if there was any direction from the Archdiocese to take advantage of this child or children who were in the parish, the case
that would be easy. That would be easy. And I'm not
easy. But is that statement by that statement legal determination by the appellate division that he was not acting within the scope of his responsibilities when he sexually assaulted this child, if he did, and I know it's an allegation, is that wrong?
So let me, for purposes of making my next point, let me concede that and I don't mean to frame it as a concession like this is something that you're pulling out of me, right? That the act of abuse itself is not something that anyone would understand as within the scope of the job of a priest. Or really any kind of job.
So how is agency even because if they were, hypothetically, if they were directing him to abuse children and to do so in New Jersey, then jurisdiction and agency would be dealing with the same facts here. But we're not.
Obviously. So the answer lies in the fact that there's a broader continuum of conduct that's at issue here. I get that if this analysis telescopes down to the act of abuse itself, I mean, obviously we lost in the trial court, we lost in the appellate division. I'm standing before you now, so this has been an uphill climb, right? But if we are telescoping down to the moment of the abuse itself, that slope gets even steeper. Right.
Why is the answer not Section 219 of the restatement second of agency adopted in Lehman and quoted again in Hardwick, that a master is not subject to liability for the torts of his servants outside the scope of their employment unless, and then there's 4 separate exceptions, and one of them is the servant was aided in accomplishing the tort by the existence of the agency relation. I thought your whole argument is that even if the abuse was outside the scope of employment, the only reason that a priest was able to commit the alleged abuse was because he was a priest and he was able to convince the mother to send her son with him for the weekend because he was a priest and ministering spiritually.
So Justice Apter, that's yes, we highlight this section in our briefing, and this is exactly why I embrace the observation that you made, and this is why I want to push back on the idea that the moment of abuse is and the question of the Archdiocese's vicarious liability for the act of abuse itself is the black hole into which the jurisdictional analysis collapses. There is a larger continuum of conduct that starts with the fact that the Archdiocese hired Michael McCarthy, encouraged him to develop spiritual and counseling and pastoral relationships with families, encouraged families to trust in their priests.
But even if you're right about all of that, where do we learn that is sufficient for personal jurisdiction? Because it just seems like your argument means that anytime an employee abuses their authority to commit a tort in a state, that will mean that their employer is subject to liability in that state. Because the fact that the employee abused their authority that they got from the employer in order to commit the tort, you are saying by definition means that there's personal jurisdiction against the employer, even if the employer didn't do anything to purposely avail itself of the laws of that state.
If the facts are as you describe, I might agree with that. But those facts, but your scenario is not this scenario. This is a scenario where Father McCarthy, within the scope of his employment, which included developing and fostering pastoral and guidance relationships with parish youth, and in particular with DT, whose father had died, and the mother had asked, and Father McCarthy had said, "Let me take this child under my wing." And yes, sir.
But how then, counselor? How are there any quote unquote real limits? Right, that's what Ford requires. There have to be real limits that protect the Archdiocese from jurisdiction in New Jersey. How are there any limits at all? Because what I hear you saying, sort of picking up on Justice Pierre-Louis when she was talking about, it almost sounds like it's anything. For me, it almost sounds like you're saying this could happen anywhere. It could happen in Hawaii. It could happen in California. There's nothing in your papers that ties this to New Jersey. Your list: pastoral relationships, spiritual counseling, comfort grieving. That was your list. Nothing in that has anything to do with New Jersey. How, therefore, does it satisfy Ford's test that there have to be, quote unquote, real limits that protect the Archdiocese from this form?
Well, on these facts, and I am respectful and sensitive of necessity, but also respectful and sensitive to the question that you raised, because I get the idea that in theory, Father McCarthy could have said, "Hey, let's get on a plane and fly to Hawaii," and that would be, and then would the Archdiocese be subject to the jurisdiction of the Hawaii state courts, which maybe Mr. Centrella would not mind, but that would speak, I think, fairly to the concern that you have identified. But this is a record where Father McCarthy had this home. He was taking children to this home. It was known that he was taking children to this home and families to this home. And what happened here, and this is the nexus between agency law and jurisdiction. This is the cross connection, right, between them, where the exercise of jurisdiction makes sense on this record, is that Father McCarthy, within the context of his job, was within the context of developing and fostering relationships with the family and with DT himself, did in fact take DT to New Jersey. And what the Archdiocese is doing, when we think about the concept of purposeful availment, I understand that there's not something like a commercial transaction where the Ford company says, "We're going to sell our cars in Montana," and so there's a decision from Detroit that we're going to spend money in Montana. What the Archdiocese did was to repose a job in the priest. And what the priest did was to take the child to New Jersey, and in that sense, through the relationship, through the Archdiocese relationship with the priest, in that sense, this is not random, fortuitous, or attenuated. In that sense, the claim does arise out of or relate to the entire course of conduct in New Jersey, which includes abuse. Yes, it does include abuse, but it also includes all the other dimensions, all of which are activated by and within the context of this job description. And
the other dimensions are not the source of the lawsuit. I'm sorry. The other dimensions, the role, pastoral role, et cetera, that's not what the lawsuit is about. The lawsuit is about a sexual abuse allegation taking place in a New Jersey private residence. That's it. So when we go back to purposeful availment, and so the defendant must take some act by which it purposely avails itself of the privilege of conducting activities within the forum state. That act is having and I'm not dealing here with vicarious liability here. Mm-hmm.
Yes,
I get your argument on that, but that act is having this priest be, as you say, and I'm not, obviously that's for a different day, an employee, and giving him responsibilities that on paper and are ordinary pastoral responsibilities. That's the act that constitutes availing themselves of the privilege of conducting activities in New Jersey. When we're not dealing with the property they had, you won your other case on that.
So the due process framework, if we think about Bristol Myers Squibb and Ford, has organized the following formulation, which is that specific jurisdiction is appropriate where the plaintiff's claim arises from or relates to the defendant's conduct in the forum, such that there is, where, to put differently, the Supreme Court's words, not my words, put differently, where there is an affiliation between the defendant and the conduct and the forum. And in that framework, Justice Patterson, my submission to all of you is that the entire course of conduct is at issue. It's arising from and relating to. This is not a question of teleporting into the home and then teleporting back. There's a whole a storyline here about Michael McCarthy, his efforts in Pennsylvania within the context of his job, and then yes, bringing families, children, and in particular DT to this home. And so I might acknowledge again that if
cause of action for bringing generally families and children.
Sure. So we're focused here on
cause
DT.
of action for, he didn't get into a car accident with a van full of kids. This is a very specific instance in a very specific location.
Well, that is all true. And my contention is, and obviously I'm here to present this, right? But my contention is that the abuse, the claim arises from and relates to the overall course of conduct of the Archdiocese in New Jersey. And I do recognize that the fact of the abuse
parts of that course of conduct
the
in
part
New Jersey.
In New Jersey, well, I mean, it's simply put, and I simply put, Father McCarthy it's a circle, right? Father McCarthy picks up DT in Pennsylvania and drives him to New Jersey and has a home there and hosts DT at his home.
So that's the course of conduct.
That is. I mean, I don't want to try to make any more of this than what it is, but that is the course of conduct. And my suggestion is that course of conduct is within is in furtherance of is sold and setting aside the difficult and tragic and horrible fact of the abuse itself is billed or sold or understood as within the context of a mentoring and pastoral and counseling relationship.
Does the conduct specifically relate to the house?
The conduct occurred in the house, but otherwise,
I'm talking about the conduct of the defendant of the Archdiocese. What connection is there between the Archdiocese and this private house?
None.
And is there anything beyond the house, attendance at mass, recreation, activities outside of the Margate home in the record?
There's no evidence of that in this record. There's evidence of he arrives at the house and there's pornography and there's alcohol and there are the events of the abuse, but I don't believe this record speaks to the idea that there is visiting other churches or something external to the house.
If I could follow up with one hypo, yes or no hypo. All the facts are the same, except Father McCarthy intended to take DT to the Poconos. But like anybody who lives in South Jersey, like I do, he made a mistake and he went over the Benjamin Franklin Bridge.
Right, which of course could easily happen.
He got into New Jersey and then in seeking to go to the Walt Whitman Bridge to get back to Pennsylvania, he and DT get in a fight and he punches DT, right? So he punches DT in New Jersey. Now, all the facts are the same, except he intended to go to the Poconos, but he mistakenly got into New Jersey. They got in a fight and he punched him before he was able to get back over to Pennsylvania. Would you be making the same argument?
Yes. I understand that's not an answer. Analytically, right? I mean, there's a lot of texture around the fact of sexual abuse, and this is Father McCarthy's home. But I think I'm constrained to acknowledge that the core argument would apply under the circumstances that you describe. Now, again, there's texture, and I'm not sure I'm making a concession. I don't want to say that too emphatically, but it does seem to me that the core argument that we are advancing here would apply, again, setting aside the sort of the different moral texture, right, of your hypothetical versus what we have here. But I do think that would apply.
Doesn't that answer ignore a critical link in your agency and jurisdiction argument, which is any knowledge on the part of the Archdiocese? Beyond mere foreseeability, which maybe you're arguing, but the appellate division specifically held there was no evidence that the Archdiocese could have known that this would happen. And doesn't that doesn't that missing piece, because it's similarly to Justice Hoffman's question, the Archdiocese couldn't have known that they would get in a fight. And here there doesn't appear to be any evidence in the record that they could have known that this would happen. Doesn't that break the link between your argument of agency and jurisdiction?
So let me just, so as a procedural matter, let me acknowledge that there was, or just state that there has been jurisdictional discovery. There's not really been merits discovery. So the discovery thus far is confined, and one can imagine fuller discovery producing fuller information. With that observation to the side, there are allegations in the complaint that the Archdiocese was aware that Father McCarthy was taking children to his home, and that the Archdiocese was aware of the risk of abuse. And those are allegations.
The allegation in the complaint was that the Archdiocese was only on notice of McCarthy's, what you call, propensity for sexually abusing young boys, beginning in 1986. So
yeah,
years after
the
incident.
If I'm looking actually at paragraph 56 and 57 of the complaint, and those paragraphs speak in more general terms. That Justice, after I understand, the complaint also refers to 1986 as being the starting point. So in fact, when you asked your question, I was about to acknowledge to Justice Noriega that I want to make that observation about the complaint rather gently, viewing the complaint in the light most favorable to the plaintiff rather than the defendant, and then to say otherwise, that the record evidence that I would point the court to is the evidence that I discussed with Justice Apter, and that Justice Apter you described regarding the fact that it was well known that Father McCarthy was taking children to his home, and that it was well known that he would leave, and that when he leave Pennsylvania, and that when he did, everyone knew where he was going. So if you put that together, maybe that's sort of enough to satisfy your question, but it sort of goes to the theme that I offered earlier, which is that I think there actually are better records in some of these cases, and there might be a more textured record here. So there was
a better record in your other case that was decided the same day, which is that it happened in Ventnor, right? That's the allegation. What happened in Ventnor, Archdiocese owned property, whole different ballgame here. And that's an example of a better record.
And this court might have the factual texture might mean different things to this court. And there's actually another case in which my office is involved, which I think has even a better record, which is to sort of underscore, I think, the core point that I'm trying to offer here, which is that it is and Justice Patterson, with due regard for, I think, the very interesting and illuminating question that you asked, that our proposition to this court is premised on the relationship of the Archdiocese to the priest, and the fact that the priest is charged with a job, and that he is doing his job, and in the context of doing his job, takes the child to New Jersey. And that could take me to less comfortable scenarios like the one that you described, but that is the core proposition.
Why are you embracing that scenario? It seems like you're accepting a much weaker record than the one that we have in this case, where parishioners and the parish and its teachers are aware of this taking place, as opposed to somebody accidentally traveling into a state they had not intended.
It is, Justice Patterson's scenario is weaker than this case. My thought, and I think
Justice Hoffman, new Justice.
Oh, excuse me. I'm sorry, Justice Hoffman.
I'll go by Justice Patterson.
Well, we're all Justice Patterson today. Sorry, Justice Hoffman and Chief. Justice Hoffman's scenario is weaker, right? It is a weaker scenario, but the thought that I think I offered or tried to offer in my mind was that the core theory of jurisdiction, the connection between agency and jurisdiction that we're offering to the court, I think would apply analytically on these facts. But this is absolutely a stronger scenario because of the pre-knowledge of the school, and generally the and the parish, and generally the Archdiocese, about what Mr. McCarthy was doing.
Does your position in this case fail if the answer to the hypothetical from Justice Hoffman is no?
No, I'm not sure if I say no what I'm answering.
Travel by accident into a different state than what was intended.
If there is no jurisdiction?
In that case. If there's no jurisdiction in the hypothetical, have you undermined your argument, or does it stand?
If the answer is no in that hypothetical, then then the argument is weaker. I don't think it's catastrophically undermined because the factual texture really does. I think the factual texture does make a difference.
Because your argument in your case and the facts in this case is that you're arguing that that there is evidence that the Archdiocese was aware that Father McCarthy was going into New Jersey, that teachers were aware, that other priests were aware. In that scenario, no one has any idea that someone's going to accidentally set foot into another state. So even if the answer is no to that hypothetical, I don't think it does much to your argument.
Well, I'm glad to hear you say that.
Well, I'm not saying.
I
just saying it's different. I mean, just following up on the Chief Justice's question, I don't know if you. To make that argument.
Well, Justice, I think what it underscores is the facts matter, right? And we'd have to ask about what precipitated the fight. Were they talking about the Eagles? Were they talking about Sir Thomas Aquinas? Maybe that actually doesn't matter. But there is a factual texture here in terms of the relationship of the Archdiocese to the priest and the job description and the mission that is given to the priest, and then the priest activation or performance of that job description, which then includes this trip to New Jersey, which I would suggest to you is enough. And I'm willing to acknowledge that this is close to the line. Like, I get it. I'm standing here, not there, right? But I think if we think about this in the context of the uttermost limits of due process, and we reflect on the fact that the Archdiocese is charging these priests with doing this job and giving them latitude, that in a fundamental sense, they own the conduct. And I'm not trying to say here that they are therefore necessarily vicariously liable for the sexual act, but I think they own the conduct in terms of what happens in New Jersey.
They own conduct that directly violated what the priest was supposed to be doing, which is pastoral care for the parishioners.
In that moment, in the moment of abuse, for sure.
Of abuse, but that's what we are talking about. I mean, that has to be what we were talking about. If we were to adopt your dividing line here, then what keeps any employer who has a code of conduct, you're supposed to behave responsibility, follow the law, the usual information that occurs in an employee handbook, that when they don't follow the law, they commit a tort, they commit a crime in another state, then the fact that they were even remotely acting, it had any relationship to their employment means that the employer is suddenly subject to jurisdiction.
Well,
in that case,
if the relationship, if the presence of the employee in that scenario is not activated in a fundamental sense by furthering the interests of the employer, then it may well be that under that factual texture, there is no agency relationship that would apply, such that the personal jurisdiction analysis and the vicarious liability analysis ends as a matter of course. But here, my suggestion to you is that we do have this act of abuse, which is very difficult for me to push to sort of rely on.
Just
right?
To be clear,
but that abuse is happening in a larger context. And if I may, the one other observation that I'd want to make is that your decision in Hardwick suggests that an employer, but more than suggests, it says that an employer may be vicariously liable for sexual abuse, and for workplace discrimination that occurs that is beyond the scope of the employment because of the legislative policies reflected in the law against abuse and the Child Sexual Abuse Act. So I don't want to push that too far, but it would be odd. That's not a jurisdiction
case. That is just simply,
fair enough. Justice Paradox is fair enough, but it would be odd if an employer could be vicariously liable for an act in New Jersey over which the New Jersey courts did not have personal jurisdiction.
You keep saying employer-employee. Was there any discovery about whether this priest was an employee of the Archdiocese?
Well, I don't know that is the framing that they use.
Whether there was any discovery on the subject matter.
There was, and it's Monsignor Kutas and also Father McCarthy that talk about their relationship. And actually, now that you've sort of highlighted this issue, I think the proper sort of framing is principal and agent. I'm not 100% sure that this is.
I need you to cover this very, very briefly because we're beyond the half hour.
For sure. Let me just say that as I stand here, and now that you asked the question. I'm actually not now 100% sure that the proper denomination is employer and employee. But what absolutely is the case is that the Archdiocese of Philadelphia charged Father McCarthy with a job that they gave him. They told him the terms of his work, how he should dress, where he should live, what he should do, right? And I understand this record as essentially uncontroverted, that Father McCarthy was working for the Archdiocese of Philadelphia and furthering, as a general proposition, furthering the interests of the Archdiocese, specifically with reference to and including providing counseling and pastoral care and support to families and to children. And it is within that context that this relationship develops, and it is within that context that this trip to New Jersey occurs, and it is within that context that the abuse occurs, all of which, recognizing the difficulty of stepping back from the abuse, is enough to ground personal jurisdiction in this case.
Thank you, Mr. Becker. We'll have you back for rebuttal.
Thank you.
Mr. Centrella.
Very much.
Thank you, Chief Justice, Associate Justices. My name is Nick Centrella, and I represent the Archdiocese of Philadelphia. Mr. Becker said something along the lines of facts matter in a case, right? But there hasn't been a whole lot of discussion of the facts of this case. And the discussion that has happened has actually misrepresented what the facts are. Misrepresentation number one is that this was common knowledge. There is nothing in this factual record that suggests that this was common knowledge. McCarthy actually, and the only thing that was even brought up was McCarthy's testimony that he may have told other people. McCarthy also testified that he bought this house in 1973, where he allegedly brought some high school students. This case doesn't relate to the high school. And to answer Justice Fasciali's question, he actually was a teacher at a high school. He lived at the parish because he needed to live somewhere, right? The high schools don't have homes for priests. So what happens is when you're teaching at a high school, you live at one of the parishes in the rectory. And this was covered in the testimony of the corporate designee, Monsignor Cutis, where he said that really your only responsibility is to say Mass, help out at Mass once a week. That was his job, to work at the high school. He was actually an employee of the high school. Now, does the Archdiocese have some level of control over him? Of course, the Archbishop is the one who assigns him to those places. But once the assignment was made, he was operating within the high school setting, and he was operating within the parish setting, but in a very limited capacity at the high schools, at the grade school setting. Okay, so how did the relationship happen with this particular family? They became friends. Okay, why is that important? Right, because we keep hearing about employer-employee relationships, but these are people, and they're priests, and they have friends, and their friends are within parishes where they work, just like all of us have friendships at our places of employment. McCarthy went to this house for this family once a week, ate with them, drank with them, became friends with them. And the testimony about him taking children from O'Hara is later, because he bought the house in 1973. And his testimony was that I bought the house then, and that I took people, and I took them because they were friends. Not because I was ministering to them, not because I was acting as a priest. They were family friends. And so now we're even further outside the context of an employee-employer relationship. This particular episode, there's not a single indication that there was anything at all about this trip that in any way furthered the interests of the Archdiocese. And in fact, as we now know, it was completely contrary to the interests of the Archdiocese, if you believe the allegation that he was sexually abused. But the testimony of the plaintiff is that the priest arranged for him to go to this house in Margate, And because it's actually prior to the date where McCarthy bought a house, we don't know for sure whose house it was. We know it was private. We know the Archdiocese had nothing to do with it. In the plaintiff's mind, what the plaintiff understood was that it was McCarthy's mother's house. Okay, he picks him up, not wearing anything to reflect the fact that he's a priest. He's wearing a polo shirt and pants, just like any other adult. He gets into the car with him, and within 20 minutes, starts to fondle his chest, telling him that, you know, you're getting too thick, you're getting too muscular. Already starting, in essence, what even the plaintiff admitted showed the real purpose of the trip. There was nothing at all religious about it. There was nothing at all for the benefit of the Archdiocese. And by the way, there was no evidence that anyone knew about this trip. And in fact, I know this came up in prior questioning, but the pastor, first of all, only McCarthy we have, right? Because this case is 50 years old. We don't have the pastor here to testify. The plaintiff had no evidence that anyone knew. He was specifically asked that, and said, I have no reason to believe or no evidence that anyone knew about this trip other than me, McCarthy, and my mother, right? And even what the mother knew or did not know is speculation or hearsay, because we don't have her here to testify about it. But more importantly, on page 768 of the record, and Justice Abner, I think this is the testimony you were citing, he was asked, did the pastor know? And his answer was, he knew where I was going almost any time I was in and out. I don't know what he did and did not know. All right? So think about this. The pastor had no control over him taking vacations. And in fact, as the corporate designee of the Archdiocese testified, priests are actually guaranteed under canon law 30 days of vacation, right? They're allowed to go away. They don't have a vow of poverty. They're allowed to own houses. They're allowed to do things that other normal individual people do, like own vacation homes and go there with friends.
I don't have the deposition pages that were cited earlier. Can you respond to the specific comments that counsel made about members of the parish, about teachers being aware of these trips being taken to New Jersey?
Again, the only testimony that even marginally relates to that is McCarthy himself, right? By the way, the same McCarthy who's accused of sexually abusing a child in this case, the same one who took the Fifth Amendment to many of the questions, the same one who denied ever abusing the plaintiff, the same one who denied ever taking the trip, right? So that's the only evidence that, self-serving evidence that exists for that. But he said that in the context of being asked about allegations that came much later on in the 1990s and 2000s about from some students at O'Hara who had went to the Margate home, a Margate home that he later bought.
Step back on that,
Sure.
if you would, because it's important that we understand
Sure.
exactly what is it that he said that, and what was the context of that?
And if you have a transcript reference, that would be helpful as well. Go ahead.
Well, he generally talked about these trips on page 767 of the transcript.
And are they
I'm sorry, 767 of the record.
Okay.
Which
And
is
are they, when we say these trips, are they DT trips?
No.
There are later trips?
They are later trips involving students from O'Hara High School, which is unconnected with his relationship with
How much
DT.
later?
Most of them came about several years later. It was 1971 as DT. These trips are in the more in the mid 70s.
Is there any evidence of, and I'm sorry, Chief,
No.
is there any evidence that contemporaneous with or prior to the DT trip, which is the core of this case, there was knowledge on the part of either other teachers or the pastor in the rectory where he was, in the parish where he was living, the rectory, that he was taking children to this private home that was either his mother's home or his?
No, not prior to the date of the DT trip.
So when there's reference to people in the parish, teachers, other teachers in the school, other people who have an affiliation of some kind with the Archdiocese, knowing about taking children, that is all subsequent to this issue.
Yes, it's all subsequent. And two, we're also flip-flopping between locations, right? That testimony related to the high school where he taught on an everyday basis during the school year, right? The relationship with DT wasn't based upon the high school; it was based upon the parish where he lived and had his minimal obligations as a priest.
I thought you just said the relationship was based upon a friendship, and now you just said the relationship was based upon a parish.
So
I think those are two very different things. I mean, I would actually challenge that the relationship was based upon a friendship. I mean, they didn't play softball together. They happened to have built the relationship because McCarthy was counseling, as he is supposed to do, was grief counseling the family. So, and when you say the relationship was based upon a friendship, and then you say the relationship was based upon the parish, those are two very different things. Which one is it?
I don't think they're two different things, Justice Hoffman, because I think they met at the parish, and the relationship didn't start with grief counseling. It started with some counseling because the father was Protestant and wanted to convert to Catholicism. So that's what started it, right? So yeah, there was a component of obviously of spirituality to that in terms of the conversion that was supposed to happen, and then the tragic death of the father before it happened.
Is there a clear, sharp line between friendship and guidance, mentoring, in the context of a relationship between a priest and a young adult?
Well, I don't know that there's a sharp line, but it also tells you exactly why it shouldn't be the basis of jurisdiction, right? I mean, the basis of jurisdiction is based upon acts which you can measure.
I'm struggling with you're anchoring your argument on the concept of friendship.
I don't believe it's an anchor. I believe it's just a fact. It's a fact that both the plaintiff and McCarthy testified that the relationship was more than simply priest and parishioner. And it's also fits in with the fact that the corporate designee testified that really this idea of mentorship, which is in large part what the plaintiff is based upon, this agency relationship and the connection with this case, that really the obligation of a priest is as a spiritual mentor. The priest is not supposed to be a grief counselor. They're not trained in grief counseling. There are psychiatrists and counselors who have that specific training. That's not their training. They're there to be a spiritual guide.
But didn't Monsignor Kudis specifically testify that McCarthy, quote, would have only gotten permission, and then it's from the parents, that's what he's referring to take children overnight to Margate, New Jersey, because he was in a position of trust, that being a priest?
Well, Monsignor Kudis did accept the proposition in his testimony that the priest is in a position of trust and that parents generally trust priests at that time frame. He did agree with that. But again, I think that issue is unrelated to the issue of jurisdiction. To get back to really what is the critical issue. The critical issue here is, what did the Archdiocese do to purposefully avail itself of the rights and privileges of the state of New Jersey?
So we know what part of the plaintiff's allegation is that the Archdiocese employed him, I'm not using the word employed, but had appointed him to a position in which young people might tend to trust him. That's part of it. And the other part of the allegation that is specific to New Jersey is that they were aware that he was taking children to New Jersey. And you're telling us that is.
I'm telling you that's factually untrue in this record, and the trial court has looked at this record and reached that conclusion, and the appellate court, the appellate division has affirmed it. Right. So in order to make that finding, this court would have to insert itself as a fact finder and disregard the findings of the trial court.
Can you give us a little more direction as to that finding by the trial court and what it was exactly?
The trial court specifically found in its initial opinion, and I believe it's on, so we find the citation to it. So the court's original opinion was November 17th, 2020. It's page 66 in the record. And this is a quote. "This court finds it was the purposeful actions of McCarthy alone, not the Archdiocese, that created any contact with New Jersey." And that's specifically on page 79 of the record. The court, as you know, had two more decisions in this case. It reaffirmed that opinion in its latest one on August 19, 2022, which is page 4 of the record, where it specifically referred to its prior factual findings as standing.
I was actually, and I may have been inarticulate in asking the question, I was actually asking for any kind of finding as to what was known by others. Is there any finding by the trial court on that?
I don't remember specifically if the trial court made a statement upon that, but I can tell you that it was a large part of all the arguments in this case, and a large part of discovery, because what may not be apparent from the record that you see is that discovery in this case and in related cases or cases that had similar fact patterns was conducted not just on the allegations of each particular plaintiff. Right. In each of these cases, because of some rulings in some of them where originally there was a bunch of them in Cape May County, and the court said, I'm going to give them discovery 5 years before each allegation, 5 years after each allegation of every allegation against any priest in New Jersey. And when you block them on top of one another, you basically got 30 or 40 years worth of discovery, almost every allegation that's ever been made against the Archdiocese in New Jersey. And
you have a very good record as to what was known and when.
Correct. And in none of that record, and by the way, that record was part of, some of it was part of this record because this court allowed the same 5 and 5. So 1971 is the allegation. They allowed discovery on allegations against the Archdiocese from 66 to 76. And no evidence was accumulated that the Archdiocese had any knowledge of priests taking children and abusing them into New Jersey, or quite frankly, even taking them into New Jersey.
And how about McCarthy? Is there any knowledge of McCarthy taking children into New Jersey that is 1971 DT's relevant or before?
No.
So the only evidence in the record as to McCarthy taking children or high school students into New Jersey or any minor is, I think you said several years subsequent.
Several years subsequent to it, where, and again, that's just him saying, I told other priests. He doesn't say which priest. He doesn't say where. He doesn't say what he told them.
And what is it that the other teachers knew?
We have no knowledge of what the other teachers knew, other than what McCarthy generally claiming that people knew. I mean, it was just a general statement.
People knew what? I'm sorry to be harping on this, but people knew what?
I think that he had taken trips with students. I think that was the only thing he said.
To Margate?
I believe so. But again, I believe this was him answering questions 50 years later to justify why he did what he did. There's no, I mean, there are other parts of what he said that the plaintiff wants to completely disclaim. Like, I didn't abuse him. I didn't take him to New Jersey, but hey, well, let's believe him on these self-serving things where he tries to.
Is that inappropriate for us to look at the record?
I don't believe you should. I mean, you obviously have the record in front of you, but I believe that the trial court is the one that should be making those kind of determinations.
Did McCarthy say that other people knew about him taking trips with minors before, at the time of the DT incident, 1971, or before?
After.
It was all after.
All after.
So that's the one thing I want to focus on, that every bit of your contention is, and obviously we have some of this, I guess, in the record, your contention is that any testimony about other people in the school or in the parish knowing that he was taking minors on trips to New Jersey was later.
Yes, other than him saying that the pastor generally knew where I was going, which is why I quoted the language I did, because he also said, I don't know exactly what he knew about those trips, right? So, I mean, the pastor would tell the pastor, I'm not going to be around at the parish this weekend, I'm going down the shore, right? That's just part of normal work environment in terms of letting people know where you are and common courtesy for somebody who's living with another person.
But your assertion is that as to him taking children to the Jersey Shore, there is no evidence that that occurred either at the time of the DT incident, 1971, or before.
Correct. But I also want to add, Your Honor, that I think this inquiry is also irrelevant, maybe too strong of a word.
If it is or it isn't, I'm just trying to get at the facts.
Sure.
Because you when you stood up, you said that the facts were not represented properly by your colleague on this side. And I want to understand what it is that you say were the facts.
So the factual record, as we contend, is that there was no knowledge prior to the trip of McCarthy either engaging in such conduct with DT individually or, quite frankly, with anyone else. But I also want to point out that it's been the law since Burger King and other cases that we've cited extensively in our briefs, that even if the Archdiocese had known, that in and of itself wouldn't be enough. You would need something more than knowledge. You would need purposeful availment. You would need intentional, deliberate acts. Right? Knowledge itself isn't enough. Right. And I'll give you an example of that involving this court, the J. McIntyre case, a Supreme Court case, U.S. Supreme Court, 2011.
The Castro.
I'm sorry.
Castro versus
Castro, yes.
Yeah.
The Castro versus J. McIntyre, where a product was shipped into New Jersey. And in those cases and cases like it, the courts have said, you may know that there's a potential that your product may end up in New Jersey or some other state, but unless you took direct action to market it, to do the kind of things they did in Ford, right? To directly target a marketplace, then it's not enough. You need more than that. And I've been going for a while. I want to go back to I want to go to really the agency because I haven't touched on that all that much. All right. So plaintiffs and Mr. Becker was pretty direct in saying that the linchpin of his argument is agency. All right. But the linchpin of his argument is state law agency. And this court, right, cannot apply state law agency to a federal constitutional issue for a number of reasons. First, this court has already, kind of had that question. The Abamon case, which plaintiff cites in their brief, that case involved state court liability. It did not involve any federal constitutional issues. It did not involve jurisdiction. But interestingly enough, it did involve a federal claim. It was essentially an employment claim. It had a state law component employment claim. It had a federal law component employment claim. And in that case, for the state law claim, this court applied state law and state agency law. And for the federal claim, the court applied federal law.
Why isn't your argument broader than that in saying that agency law doesn't drive the train here?
It doesn't. It doesn't in any respect because
federal or state.
It doesn't drive the train because what Daimler, what all the Supreme Court cases that talk about purposeful availment say is that it has to be the acts of the organization.
So I think the reason that I'm confused about that is there's a bunch of cases specifically against different dioceses that are saying that there's no specific jurisdiction in a particular case because the priest was not an agent or was acting outside of the scope of their employment. So they're specifically considering agency law. There's Doe versus Roman Catholic Diocese of Erie, Pennsylvania. That's the Northern District of New York. Tell versus Roman Catholic Bishops of the Diocese of Allentown. That's Delaware Superior Court. Tercero versus Roman Catholic Diocese of Norwich. That's the New Mexico Supreme Court, I believe. Archdiocese of Detroit versus Green. Florida District Court of Appeals. And in each case, they're saying no personal jurisdiction because there was no principal agency relationship between the Archdiocese and the priests in this case. So where do we see a case that says agency has nothing to do with personal jurisdiction? All of these cases are wrong for even considering whether there was an agency relationship because it just has nothing to do with personal jurisdiction. There's agency here, there's personal jurisdiction there. They have nothing to do with each other.
Yeah, unfortunately, I don't know that I could answer that with a simple yes or no answer because I think what those cases are looking at is the fact that let's take Daimler for example. That in the Daimler case in footnote 13, it specifically mentions how a corporate entity may purposefully avail itself. And what it says there is that a corporation can purposefully avail itself by directing employees to do things. So the employment aspect comes into it in that specific circumstance because a corporation is acting through its employees.
Correct, but all the cases I just mentioned have nothing to do with sales or corporations. They're specifically against archdiocese, where the court is looking, okay, was the priest the agent of the archdiocese at the time? And they're looking at that within the context of personal jurisdiction. So I'm asking, if it is so generally acknowledged that agency has nothing to do with personal jurisdiction outside of a corporate context about selling products, why are all of these cases saying, okay, there's no personal jurisdiction here because the priest wasn't the agent of the archdiocese?
Because I think they're looking at it from two different perspectives. One, the courts in these types of cases generally look at the fact of whether or not knowing that an entity can only act through employees, you have to take a first step and say, was the entity doing anything to direct the activities that took place? And then secondly, the scope of employment sometimes is looked at in those cases because I think intertwined with that, they say that what the conduct here was doing was outside the scope, so it couldn't possibly been what the corporation was directing them to do.
So is this all about whether the corporation is acting when McCarthy did what he did? Is that the inquiry we should be looking at?
The inquiry you should be looking at is, what did the Archdiocese do? What did the Archdiocese do itself? Not what McCarthy did. What did the Archdiocese direct towards the forum state, in this case, New Jersey? If an entity says, Ford's a perfect example of that, right? We're going to market, we're going to sell all of our products in these particular states, and then an employee goes in and does something, they may not have directed him to do that, but it was part of their corporate plan and structure to do what they did. In this case,
so where
we don't
would we
have
be
that.
on this case if the Archdiocese said to McCarthy, and I understand this is hypothetical, not in the record, this is a kid in grief for his father. Why don't you bring him to your shore house?
That never happened. I'm sorry, you're creating a hypothetical.
I'm creating a hypothetical. I'm trying to get to the lines here.
Sure.
Are we really talking about agency, or are we talking about whether what he did was an act of the Archdiocese? And let's say the Archdiocese said, whether or not it knew he had any kind of history or whatever, why don't you take him to your shore house? Would that be enough of a purposeful availment to get them within New Jersey's jurisdiction?
If the Archbishop gave a specific direction.
Well, Archdiocese is a big organization.
Or right? But remember, the Archdiocese, people say it's a big organization, but now every school is a school, right? It's almost like a corporate subsidiary, and you have the Daimler case, which says that subsidiaries don't necessarily bind unless there's alter egos.
Assume for purposes of the hypothetical that it's the Archdiocese acting. Let's not get into who speaks for the Archdiocese.
If the Archdiocese gave a specific direction for him to take the child to New Jersey, then yeah, there probably would be jurisdiction.
Is there anything in the record to suggest that the mother was asked permission by Father McCarthy?
There is. Again, the testimony of the plaintiff himself, but he also says he wasn't there for it.
No, but doesn't the Monsignor Kudis, the corporate designee, also agree that, quote, McCarthy would have, quote, only gotten permission from the parents to take children overnight to Margate because he was in a position of trust, that being a priest?
Yes, but he didn't have firsthand knowledge. He was just saying it was consistent with his general experience.
Assuming that happened, wouldn't that be the Archdiocese asking permission of the mother? And that would be the only reason the mother would give permission, that it is the organization that has asked her for permission to have her son taken across state lines rather than the individual priest as a friend. Is there any evidence in the record to suggest it was done as a friendly gesture that she might have allowed, regardless of whether or not it had anything to do with the church?
Yeah, I mean, the quote that plaintiff gave as to the purpose of the trip was to have a good time.
That was the plaintiff, but I'm
The
speaking
plaintiff,
about.
but we don't have the mother's not alive, so we don't have testimony from the mother. We could speculate, and people have, and people have their opinions of why she allowed the priest to take the child down to New Jersey. But the reality is she wasn't here. She's deceased.
But the Monsignor's position was that it would have only happened with permission based upon
his experience, there would have been permission, but that doesn't make it the act of the Archdiocese. Again, it's in the individual, right? There's no indication that the entity, the Archdiocese entity itself,
Monsignor
asked him to do that.
Monsignor didn't say, no, this never happens. We would never in any way foster a child being taken to a private New Jersey vacation home. What can we reasonably infer from the answer the Monsignor did give that Justice Wainwrapter asked?
No, he actually testified he was not aware of that ever happening in his experience. It didn't happen in any parishes he was in. It didn't happen among his friend group. The only reason he even knew about that happening was by reading the allegations in this case and other cases in order to prepare for the deposition. So it was not a widespread practice, and there's no evidence that it was a widespread practice other than the fact that we now have allegations 50 years later relating to some of those cases. And if you look at the pattern is exactly this case.
But whether it was widespread or not, was there any evidence in the record of priests traveling to New Jersey for church-related activities like recreation or mass?
No, not that it doesn't happen occasionally, but not related to this case. And there was really no record developed of what those other situations might be.
I thought, I'm sorry, that Monsignor Kudis also testified that part of a duty of a priest is to promote Catholicism by taking camping trips or other spiritual adventures outside the geographical area of the diocese.
He did say that, but those trips were, most of those trips, and in fact, one happened that DT talked about among altar servers. They happened within the state of Pennsylvania. And they could happen. There was no prohibition on a trip, someone taking a class trip or an altar server trip to New Jersey. But again, that's where we haven't talked much about the second prong, right, of personal jurisdiction, and they have to be related to the actual incident or cause of action. So the fact that there may have been class trips, and by the way, class trips would have the ability to have other adult supervision, school sanction, right? That would be that could potentially be a purposeful aspect of it, but they would have all other types of protections that a priest individually taking a child didn't have. And he unilaterally did it. There's no evidence that it was anything other than a unilateral act of the individual priest.
So was there discovery about whether he asked any kind of permission to do this, to this particular trip?
Yeah, he testified that he didn't. He testified he did not ask for permission.
I'm sorry, was that from the mother or from?
He asked for permission. I'm sorry.
And my question was the Archdiocese.
Yeah, the Archdiocese. He did not, McCarthy specifically said he did not ask for permission from the Archdiocese.
If I could expand Justice Patterson's hypo from before a little bit and just take New Jersey out of that hypo and just have the hypo be that the Archdiocese would tell the priests, I want you to take trips outside, anywhere you go, tri-state area, wherever, but it's okay. It's in fact, it's positive in a scenario in which you're doing, say, grief counseling, to take an individual away and give them an opportunity to enjoy themselves, to speak openly. And so without putting New Jersey in it, but manifesting an intent that they do travel away to areas in which sort of it could be positive for the individual they were working with. Does that change your answer?
No, it doesn't, because the constitutional requirements for due process for personal jurisdiction require intentionally targeting a jurisdiction. And in that hypothetical, I answered yes for, I think it was Justice Patterson's hypothetical, because there was a specific direction to do it in New Jersey. In Justice Hoffman, in your hypothetical, it's an open-ended one. And it's not directed to any particular state and could be accomplished within the state of Pennsylvania without ever leaving the jurisdiction of Pennsylvania. So it might be outside the jurisdiction of the Archdiocese because there's the Diocese of Harrisburg or Allentown or Pittsburgh or a bunch of other ones. But your hypothetical, it gets to a point I also wanted to raise, which is if you would accept plaintiff's position, in essence, and this was raised by one or two of the justices in the questions of Mr. Becker, you would in essence have unlimited jurisdiction, right? Because if what the Archdiocese is going to be held to be subject to jurisdiction is the instruction that you should go out and mentor undefined way, then there really is no limit. You know, the Hawaii example was used, but there's really no limit. Any jurisdiction that accepted that theory, there would be worldwide jurisdiction, and there without any direction or targeting by the Archdiocese of that specific form.
So if it ended up being in the Caribbean, this could be a case tried in a foreign country.
It could be anywhere. The second problem with the theory, and particularly the adoption that I wanted to get back to agency law, is it would result in really inconsistent results. Because the Hardwick decision, for instance, which relies on the restatement of torts section 219. And remember that section of the restatement is specifically titled relating to acts outside the scope of employment that may subject somebody to liability, right? So it's liability, it's not jurisdiction. But what's really important about that is outside the scope. So if it's an act outside the scope, right, by definition, it's not being done at the direction of the employer. And now you're using a section which deals with liability for acts that are not the purpose or intent of the employer, and extrapolating it to find jurisdiction over an entity that did nothing to avail itself of the jurisdiction. So, and by the way, many states don't adopt that. A lot of states don't use that formulation. And in fact, the restatement third that came out deleted it. And one of the panels in the appellate division a couple of years ago pointed that out and questioned whether that's even good law in New Jersey. Now,
your argument was that concept, it's an agency concept.
Correct. But my point is that if the court I don't think an agency concept should be adopted. But my point is, if the court were to follow the direction of the appellant and use state agency law principles, it would result in inconsistent results depending on what jurisdiction the case was pending in, which is really inconsistent with a federal constitutional argument. And so you would have inconsistent results. You would have unlimited jurisdiction all over the world. You would have no limits at all in terms of where the Archdiocese was subject, or quite frankly, any other organization was subject to jurisdiction.
Are there any limits to that argument if we were going to go down the road of the agency claim that is being presented here? Because any religious entity presumably would say, we don't sanction this sort of abuse. Of course not. We may be aware of it, but it's outside the scope of employment. Any limits to the argument you've just raised?
I'm not completely understanding the question, Your Honor, in terms of limits to the argument. The argument I'm raising is that you can't have essentially vicarious personal jurisdiction. It has to be the conduct of the entity itself.
So awareness and not putting a stop to it would not be adequate.
Awareness and not putting a stop to it would not be enough under Burger King and its progeny, which says that foreseeability and knowledge is not enough.
But you did say that if they directed him to take DT to his private home in New Jersey as part of his so-called counseling role, then that could be enough for personal jurisdiction.
That could be different because then
it's a limit, right?
It's a direct, right? That's a limit. It's a direct.
That is purposeful availment of New Jersey. That may not even be their house in New Jersey. That's a different issue. But that directing him to go to New Jersey and use his private home or wherever, take him somewhere in New Jersey would be enough. So
correct. That's a different scenario because now there is purposeful direction from the entity itself, and that could give jurisdiction.
But absent the express direction, different ballgame.
Correct. And there's one final point I want to make that we've put in our brief, our supplemental brief, because there's an undercurrent in all of these arguments that, quite frankly, potentially violates the First Amendment, the Establishment and Free Exercise Clauses. Because I don't think we'd be here if these were not priest cases, right? And the argument was being made that a priest is mentoring. In essence, the testimony of Monsignor Cutis of his religious beliefs and the beliefs of the Archdiocese that priests act in the image of God, in the image of Jesus, and have an obligation of spiritual mentoring. And that's an important distinction, by the way. He didn't agree that they mentor. He agreed that they spiritually mentor, which has nothing to do with this trip. There's nothing at all suggested any spiritual mentoring was going on. But even the concept of spiritual mentoring is a religious concept, right? That would not be applied to a secular organization. A secular organization, a teacher, a coach, we would not be having this argument if they unilaterally took somebody to New Jersey, right? Because that concept of spiritual mentoring wouldn't be there. So in essence, the undercurrent of this case also is to apply a different standard to the Catholic Church than they would apply to a secular organization because of its own belief in mentoring spiritually children.
Was your First Amendment argument before the trial or the appellate division?
It was in every brief, yes, Your Honor.
Anything else you'd like to?
I think they stayed away from it because they didn't. It was only an issue if they found that there was jurisdiction under the theories that the plaintiff asked for. Because they found that there was no jurisdiction, they never needed.
I'm not sure you're right that there wouldn't be. If there were a private school, Hardwick is an example of a non-religious private school, and the private school directed. These children are boarding. We have to provide a familial type of environment for the children, and therefore you should take this child to New Jersey. I think we'd be having the same conversation.
If there was direction like that, we might be, but would we be having the same conversation if it was a public school teacher who became friends with the family, ate dinner with them once a week, had drinks with them once a week, and then took them to their private home unrelated to the activities of the school? I don't know that maybe we would, maybe we wouldn't, but I don't think.
I'm not so sure your allegation that there wouldn't be a non-religious analog to this.
There might be, but the arguments would be different.
Anything you'd like to add to your argument?
No, Your Honor.
Thank you.
Thank you.
Mr. Daniel.
Good morning, Your Honors. Alex Daniel on behalf of the New Jersey Civil Justice Institute. If the allegations in this case are true, then we are all witnesses to a continuing tragedy. There is no question that the scourge, sexual abuse of children by clergy, is a shame in New Jersey and across the country. There's no question. And that's why what I'm about to ask you to do is extraordinarily difficult, and that is to disregard facts irrelevant here to the very narrow question of specific jurisdiction. When our courts discuss holding a principal to account in a New Jersey court or any court, the activities of one of their agents, our courts use words like control, direction, encouragement, knowledge, opportunity to act, because those are the hallmarks of purposeful availment. There could be no purposeful availment without those concepts. My colleagues have mentioned that facts matter. I think this case turns on something else. This case turns on the absence of facts. Here, absence of facts, demonstrating that the Archdiocese of Philadelphia controlled Mr. McCarthy's conduct with respect to this specific plaintiff in this specific incident in New Jersey, in Margate, New Jersey. I believe it was Justice Patterson who asked for an example of a case where a single employee's sole act in a state can create personal jurisdiction for an out-of-state employer. I don't have that case. I have the opposite. I believe in our briefs we cite to Glickman v. Anderson. In that case, a Florida company's car was stolen after a negligent employee left the keys in the vehicle, somewhere around the vehicle. That car ended up in New Jersey, resulted in an accident. That out-of-state business was hailed into a New Jersey court to answer for its employees' negligence. And what did the appellate division find? Well, the appellate division looked at that situation and recognized that the only contact that that employer had with the state of New Jersey was actually recovering the vehicle. Other than that, it never directed a single employee into the state, never sent any products into New Jersey.
Sorry, in that case, you're saying that the employee's negligence didn't even happen in New Jersey because the employee negligently did something to the car in a different state.
Happened in a different state, the injury was felt here.
Correct, but that's not what we're talking about here.
It isn't a perfect fit, admittedly, but it's about as close as I could find in New Jersey case law to a situation where you're asking an employer to be hailed into a New Jersey court to account for their employees' misconduct. And in that case—
In New Jersey, though, that was the question. Okay.
In that case, the appellate division actually cited to another appellate division case in which it found that specific jurisdiction wouldn't exist in a situation where a husband entrusted his car to his wife to perform her own personal tasks, whatever she wanted to do that day. And in turn, that wife got into an accident outside of their jurisdiction. The appellate division looked at that case and analogized it and said, actually, that's very similar to what we have here. And it made a point. Absent that control over the instrumentality, absent some other connection to the state of New Jersey, there was no personal jurisdiction in that matter. If we look at Doe v. Diocese of Richmond, we have another example of courts grounding their analysis in control. In fact, in that case, the priest at question was found to have repeatedly molested children, both in Richmond, New York, New Jersey. The Diocese of Richmond was aware of it. They knew. They were confronted with it. He returned to them repeatedly, and they sent him out back into the universe, encouraging him to find work elsewhere. They signed off on it.
And there was jurisdiction was found in
that case. Yeah. But the appellate division made it clear. Their exact words were that personal jurisdiction over Richmond is not dependent on the employment relationship that it had with Butler. Rather, the material fact of jurisdiction was control. They helped him find opportunities. They gave him their blessing. And as the appellate division found in that case, they sent a troubled priest off with all their encouragement to get him out of Richmond.
And send him to New Jersey.
Send him to New Jersey. They blessed his trip to New Jersey.
Counselor, you started your presentation by talking about the horrors, the alleged horrors of what happened. But you said a lot of that is not relevant to a jurisdictional analysis. But isn't that not the case? Aren't many of those factors directly relevant to the third aspect of a jurisdictional analysis, which goes to issues of fair play and substantial justice? Interest of the foreign state, plaintiff's interest in obtaining relief, judicial system's interest in most efficient resolution, shared interest in furthering fundamental substantive social policies. How could you say that allegations that pertain to sexual abuse would not be relevant to a shared interest in furthering fundamental substantive social policies?
Perhaps I should have grounded instead in they're not necessarily relevant, or they aren't relevant to the question of purposeful availment of the forum. Now,
jurisdictional test. That's the third test, purposeful availment, and whether you include in or of related to, or that phrase into that or not is, some courts do, some courts don't. But the third test is one of fair play and substantial justice.
That's true, but we don't even get to that test if we don't have purposeful availment. And that's the issue with this case. We have a gaping hole in the factual record. It seems to be the case that the Archdiocese had no knowledge of the pedophilic tendencies of Mr. McCarthy prior to 1971. They had no knowledge of his trips. There seems to be a dispute now whether or not members of the congregation, parish, staff at the school may have had some sense that he was taking other children with him to Margate, New Jersey. But it doesn't seem to be the case that either staff, parishioners knew that it was this child in this trip.
Do you share counsel for the Archdiocese's view of the record that what you just referred to happened later?
I would adopt his position on the record. That is my understanding. NJCJI.
You're here as amicus, but
NJCJI didn't have the benefit of a full and complete record initially. We were hesitant to ask the record to be unsealed initially when we filed our briefing.
As amicus, you can state the broader principles.
That's our goal. but we didn't necessarily delve into the facts until after we were admitted as amicus. And even then,
the heart of the argument, I think, is that the Archdiocese directed McCarthy to develop pastoral relationships, and I'm saying that in a very broad way. There's no evidence that they directed him to have any kind of sexual relationship with minors, but they developed that they directed him to develop pastoral relationships with members of his parish, and that relationship, as it developed, facilitated the sexual contact that occurred here. That's the allegation. That seems to be the heart of the jurisdictional argument here. What is your position on that?
I would actually quote the language used by plaintiff's counsel in his own briefing when he discussed the scope of control that the Archdiocese seemed to have over its priests. Priests had autonomy in terms of in their performance of regular aspects of their jobs. Plaintiff's counsel used terms like substantial latitude and broad discretion in the exercise of their priestly duties. So yes, Mr. McCarthy was given spiritual authority to speak to the flock. That's unquestionable. That's part of his role as a priest. But whether he was given specific instructions, whether he was asked to, whether the Archdiocese even knew that he was going to undertake these kinds of activities, bring a child with him to Margate, setting aside even the question of the sexual abuse that happened there, the record seems to be utterly devoid of that. Like plaintiff's counsel said, he had autonomy to act. There seemed to be no scope of employment in this regard, or whatever it was as broad as humanly possible, fit within virtually an unlimited universe of spiritual duties that a priest or member of the clergy may have.
Does your client share the view of the Archdiocese that concepts of agency are irrelevant to the jurisdictional question? And if so, why is it, why the cases that, for example, Justice Wayner-Apter mentioned, why are they talking about scope of employment?
I think because
something different from agency there.
Our position is agency, or the acts of agents, as the Supreme Court's found time and time again, the acts of agents can ultimately render jurisdiction appropriate in certain circumstances, so long as the actions of the agents are at the direction of the principal. We find that repeatedly throughout our case law. In fact, if you look at, there's a case in the District of Delaware, it's a Third Circuit published opinion, I believe it's DuPont's, I'm going to absolutely butcher the pronunciation, DuPont Agfa Gewert. That would be 335 F SUP 3D 657. In that case, we're talking about corporations, not necessarily tortious conduct, but the court made it very clear that while the agency relationship matters, it's not the very fact that it exists that defines the contours of specific jurisdiction. It's instead defined by the degree of control exercised by one entity over another. In that case, the District Court of Delaware cited a number of factors that you would consider. For instance, whether there were shared directors between the businesses, whether or not one had financial control of the other, set financial parameters for the other, whether they had such things as indemnity agreements between them, whether they assisted each other in manufacturing goods, whether they actually manufactured the same goods. But even then, the district court made very clear that one factor is not dispositive. It's a constellation of factors. It even directly mentioned that having shared officers standing alone isn't enough to confer specific jurisdiction.
Is there always a finding of direction or control in any case where jurisdiction is found in this kind of setting?
I think realistically, when we look at unfortunately, the cases involving clergy, the knowledge of pedophilic tendencies and the response to that knowledge and the ability to control priests and the authority to control those pedophilic priests is of critical issue to the court. It's a material fact to the court. Indeed, Dovey Diocese of Richmond made very clear they knew that their priest, Mr. Butler, was a dangerous pedophile. They knew he was molesting children, and as the court found, they had the authority at any time to act. They could have canceled his employment, they could have pulled his ticket and stopped him right then and there. So it's not just knowledge, it's also the opportunity to control, it's the authority to control the employment relationship, to cease the activity, the harmful activity.
But it's not, as you said at the very opening of your argument, it's not limited to specific express direction. You mentioned knowledge, you mentioned encouragement as other factors to be considered.
Absolutely. And they're all missing here. That's the critical point. At a baseline, I believe counsel for plaintiff mentioned that this case was on the very fringes of due process. It's not. It's well outside the metes and bounds of due process. We're not talking about a situation where we have any examples of direction, control, encouragement, or opportunity to act. The Archdiocese, whether we're talking about cardinal in charge or his assisting staff, principals within the Archdiocese, didn't seem to be aware of any of these activities prior to 1971. First knowledge that he was a danger to children only came in the 1980s. They had no meaningful opportunity to act. His authority was spiritual authority. They weren't delegating to him custodial control over children at the time, certainly not in the case of DT. They didn't have any specific custodial control over DT. McCarthy went to his mother. His mother, trusting a priest, allowed McCarthy to take a child across state lines. That wasn't the Archdiocese. They weren't the ones who had the authority in that moment. They weren't the ones with the knowledge in that moment. They weren't the ones with the opportunity to act. And as tragic as it is, and as much as I wish this case never happened, this case represents the furthest possible, if we're going to find personal jurisdiction here, it is the furthest possible extent that I think the due process clause could go.
You represent, your client is an organization of businesses in essence. What do you see as a business analog of jurisdiction if the court were to accept the plaintiff's theory? Well, in our briefing, we mentioned a hypothetical involving a rideshare company that would be operating outside of state lines that's specifically geolocated such that its drivers would know not to go into the state of New Jersey. They wanted to avoid New Jersey for whatever reason. I don't know why anyone would, but it happens. We have great pizza. We have great sports. I don't know why people would want to come here. But in the event that they did, in that situation, if this case is precedent and that thin connection between a principal and the state of New Jersey is enough to result in personal jurisdiction, a rideshare company that does everything in its power to keep its drivers out of New Jersey could suddenly find itself hailed into a New Jersey court if the driver decides to go across the bridge, get gas in New Jersey, and hits a car, gets into an accident, kills someone, injures someone, just causes property damage, whatever it is. Despite the best possible efforts of that rideshare company, that business, to avoid New Jersey markets and to avoid New Jersey jurisdiction, all of a sudden, one of its agents can suddenly create jurisdiction out of whole cloth against the wishes of that company, against its express goals. It's limitless. And as Daimler, as Ford, as all these cases harken back to, the due process clause stands for, if nothing else, limits on the ability of the state to hail people into its court who don't otherwise exist there. And when you say against its express wishes, is that because the Archdiocese direction to priests is to minister to them? Well, I believe it's in the briefing, there's a description of the spiritual territory of the Archdiocese. Historically, within the Catholic Church, a parish, a diocese, an archdiocese has a delimited area in which it can operate. Its priests leaving the Archdiocese would have to ask permission from a local clergyman. I believe typically it's a bishop, but also can be a parish priest, permission to hold mass there. There are limits on their spiritual authority. They can act within their little fiefdom, but that's about it. You're saying that they would have to ask permission of a New Jersey if they want to have a mass. They have to ask permission. Absolutely. Or to engage in other spiritual services, whether it's offering confession to people, celebrating marriages. Typically within the Catholic Church, if you're from outside that diocese, you have to expressly ask permission to operate within another diocese.
Daniel, I think we have your position. Is there anything else you'd like to add in wrapping it up?
No, thank you, Your Honor. Again, the position of the New Jersey Civil Justice Institute is ultimately that if we find personal jurisdiction in this case, it is an unlimited form of jurisdiction that will forever follow any agent of any principal, regardless of the principal's needs, wants, desires, activities, goals, directions. It doesn't matter. On this thin record, personal jurisdiction expands in a fashion that it never has, as far as I'm aware of the case law before. Thank you.
Thank you, Mr. Becker, and we appreciate you'll need all 5 minutes. At some point, I hope you can address the different characterizations of the record, in particular, knowledge and awareness in the 70s as opposed to the 90s based on the passages that we've been directed to look at?
Sure, Your Honor. So there's no question, there's no question that as time passes, and in the 80s and 90s, I think the knowledge and awareness of Michael McCarthy's tendencies, predilections, and practices becomes better known, right? And there is, I think, some good texture in the record, and frankly also the complaint, as to what is
Let me ask you more of a bright line question. Is there any evidence of knowledge of that prior to, I believe the date is 1986?
So the testimony that I would point you to is the testimony that Justice Weiner-Apter mentioned, and that I was discussing with her earlier, and it's not in my, I think it's, well, I have it written down here as pages 786 and 787 of the record, and I think it may span a few pages on either side of that. And I would confirm it if I walked over to my appendix, but I will not do that. But it is the passages that we cite in our brief and the passages that were discussed earlier, to the point that that the parish priest and folks at the high school knew where Father McCarthy was going and knew where he was at all times.
So Mr. Centrella indicated that those passages related to questions about Father McCarthy's home that he purchased in 1973, which would have been a couple of years after this incident with the plaintiff. So can you give us more clarity? Is that correct? That in response, that the passages that you are citing in the record, do those relate to questions about individuals at the high school learning about Father McCarthy taking high school students to that shore home that he actually purchased, as opposed to the incident with DT prior to him purchasing the home in 1973? What is your position on those facts?
So without taking a position, I think a fair reading of that passage, of that entire passage, is that discussion is in the context of high school kids, right? I think
is it also in the context of a home that Father McCarthy purchased in 1973, which would have been a couple of years after.
That's true.
The trip with.
That's true. I think the home, Your Honor, was a family home, and then he subsequently purchased. So it is the same home. My understanding. And I can't cite you chapter and verse on this, but my understanding is that Father McCarthy purchased the home, right? But the home where DT was abused is the same home where he subsequently took children after he had title to the house. But it is the same home throughout.
But what is the reference to? What's the time frame of this knowledge about high school students?
Oh, it is after 1971. That is true. Just so I don't want to try to push the record beyond what it can.
So it is subsequent knowledge of activities that he was conducting or may have been conducting with respect to high school students, which is not this case, and it's later.
So the texture, the larger context of that discussion, I think it's fair to say, and Mr. Centrella, who doesn't readily agree with me, I think will agree, that the larger sort of texture of that discussion is around high school students. But the testimony of Father McCarthy is that the people at the high school and the parish priest knew where he was and knew when he was out of state and knew what he was doing.
But I'm just very focused on timeframes. Do you see what I'm saying? Because it's the heart of your allegation that there was some sort of knowledge on the part of the Archdiocese. Is there any evidence that on the date, and I don't know the precise date of this event in 1971, but from 1971, that date, whatever it may be, or before, there was knowledge on the part of anybody connected with the Archdiocese of trips to a shore house by McCarthy?
I am not aware of that particular evidence in the record. I've pointed, Your Honors, to the passages that we have relied upon, and I can't provide you with a clear factual record that the Archdiocese or that someone at the parish priest had specific knowledge in the 1960s that he was taking kids to the shore. We point you to this testimony, which I grant you is in a slightly different texture, but I will propose that a fair reading of that discussion is that when he talks about the parish priest knowing where he is, he's not talking necessarily about something that began in the 1980s. This was his pattern and practice, and this was the relationship that he had with the parish since 1963 when he received his appointment in the first place.
So when the priest is, it seems like we've got the priest knowing where he is. It's at the shore. Is there any evidence that the priest knew he was taking children?
Prior to 1978.
Prior to 1978.
There is not, to my knowledge, there is not specific evidence in the record to that effect. There is the passage and passages that I have described to you.
So based on what is in this record, is it fair to say that your argument is premised on the Archdiocese's charge to priests to be pastoral and advise people, and I don't want to paraphrase it improperly, but that you allege became a conduit for McCarthy gaining the trust of his family?
Yeah, that is the core. That is the core of the argument.
So the purposeful availment by the Archdiocese of Philadelphia is to tell its priests to conduct pastoral activities with families.
And then if I may continue down the road, right? So there is, and I'll just read briefly because it is brief. It is the charge to know and love the people you serve, to care for the poor and needy, to teach the youth, to attend the sick and dying, to assist in the overall maintenance of the parish. That's the
purposeful availment.
That's the charge.
New Jersey.
Right. And right. Well, when you put it that way, but
well, I'm not. You put it the
yes,
way you want
exactly.
to put it. But is that the heart of the case?
That is the heart. That is the heart of the case. The way that I would formulate it is that the purposeful the availment of New Jersey is through the relationship with the priest. I want to be very transparent.
Go out there and be a pastor and do all, tend the sick and dying and do all of these things. No mention of New Jersey. You're in Philadelphia. You're in the Philadelphia diocese. That is because this individual apparently misused a relationship. The purposeful availment is to instruct priests to take care of people.
Well, I'm gonna push. So yes and no. I'm gonna push back on one piece of that. He through his charge develops a relationship with the parish. I understand he's teaching at the high school, but has a relationship with parish families, has a relationship with this family through his job as a priest. And I understand the observation that priests and rabbis and other religious figures are people and they have relationships, but there is a professional context here, and it is through that relationship that the family is cultivated, that DT is cultivated, and this is and indeed there is record evidence that Father McCarthy was very clear, and the mother was very clear that upon the untimely and tragic passing of DT's father, Father McCarthy offered himself as someone who would cultivate the boy and keep him on the right path and teach him class and to foster his spiritual development. And this was part of the charge.
And that's all what McCarthy did. But what the Archdiocese did, if we take all of this and distill it to its essence, is tell its priests operating only within the Archdiocese in terms of their pastoral duties to minister to their parishioners in the ways that you described.
That is, I think that's fair. And then the priest in turn with that charge
misused it.
Goes to New Jersey, right? And my observation to you is yes, there is abuse there. But and Justice Rabner, I know you're trying to get on to your next argument.
I'm going to jump in right now and ask you to please tell us what else you'd like to rebut in the next few minutes, because we've run short of time.
Yeah, I
apologize for that.
No,
listen, my questions. Thank you.
It's all good questions, but we need to bring the argument to a close.
My pleasure. I think where I would, if I can just sort of jump past, Justice Patterson, this discussion, because I think you know the observation that we're really making an argument through the relationship, and to say that the concept that that principles of agency have no place in a due process discussion doesn't make any sense. Of course, it has a place in a discussion of personal jurisdiction, because the acts of the non-resident entity in the state can be through the actions of the agent. And so the question around personal jurisdiction inevitably devolves into a question, of what did the company do? What did the Archdiocese do? And that becomes a question of what is the agent of the Archdiocese is doing. So it is unusual to focus so hard and directly on the question of agency in the context of a personal jurisdiction discussion, but it is natural and appropriate and inevitable that questions of personal jurisdiction reflect on the actions of agents, and then in turn reflecting on whether those actions are enough within the context of the specific jurisprudence, which is formulated as to whether the claim arises out of or relates to the conduct of the defendant in the forum. Now, with respect to the issue of purposeful availment, fair play and substantial justice, there's a lot of formulations that we have in our language of personal jurisdiction, but the test that I have described is the test that has been formulated. And I do acknowledge that there is not a record here analogous to a commercial transaction where the Ford company or someone says, I'm going to go do business in New Jersey. It's not that kind of a case. I acknowledge that there is not testimony of a specific direction. It's easier if there's a specific direction. That's the easy case. Of course, there's personal jurisdiction in that scenario. This is a little bit harder, right? My argument to you, or my contention to you, this record, what arises off this record is the concept that the Archdiocese, having charged this priest, and this priest having taken within the context of this counseling and mentoring and pastoral relationship, this child to New Jersey, and yes, having abused him there, that the Archdiocese is stuck and owns the conduct. This is their guy. And is he their agent? Yes, he's their agent. And do they own the conduct? Yes, they own the conduct. They own the entire continuum of conduct. And I understand the language of purposeful availment is less suited to this environment. But when we think about the Bristol-Myers Squibb construct of does the claim arise out of or relate to the defendant's actions in the forum, if you accept the proposition that Father McCarthy was an agent of the Archdiocese, and that in a broad sense, his trip to New Jersey was activated by that purpose. And if you also recognize that under New Jersey law, under the Abamont case itself, even an illegal act of an employee acting outside the course and scope of employment still can be chargeable
that's not a jurisdiction case. I looked for it.
It is not a jurisdiction case, but it is a case that speaks to principles of agency and accountability. And what I am proposing to your honors is that the Archdiocese here is accountable for the actions of its agent in the state of New Jersey. Justice Hoffman, with due regard to your observation about, well, what are the limits? And Mr. Centrella, Mr. Daniel's observation about what are the limits. And the answer is there are limits to the principles of due process, but there is also a reality here that the Archdiocese charged this guy with this job, and it was in the furtherance of this job that he took the child to New Jersey.
And with that, that's probably a good point for us to end.
We hope that is enough.
Sorry for rushing you.
No, look,
thank you to all counsel.
Chief Justice Ravner, it cannot be said that you rushed any of this.
Thank you. And thank you all for the very fine arguments.
Thank you. Thank you, Your Honor.
Break, or can we begin the first presentation on the next one? You need a break. That's going to be, all right, we will be back in about 5 minutes for Rem versus Irwin.